Phil, a little while ago you said, this system doesn't belong to the parties. Currently, under current law, neither major party in Oregon makes candidate endorsements in the primary election races. Under Measure 65, parties will not only make primary endorsements of candidates, but those endorsements will be printed on your election ballot. This seems to me to add a big new power to the Democratic, Republican parties and other parties. If you don't believe the system belongs to the party, why would you support this element of Measure 65?
Governor Roberts makes an assertion that parties do not. They can, however, they have the legal authority to endorse candidates now at any part of the way. Our system simply doesn't take that power away. But it does say that if a party that's legally constituted under rules that are approved, overseen by the Secretary of State, decides to make an endorsement of a candidate or candidates, that information too will be printed on the ballot, but only if the candidate agrees. I would not, for example, like the Communist Party endorsement next to my name on the ballot. So it's candidate driven. But this is a very interesting phenomenon, because if you stop and think about it, parties can do it now, and they don't. They don't in primary elections where they may have 3 or 4 good Democrats or Republicans running. They could. Now, it wouldn't be printed on the ballot, but they certainly could go out and brood it about various other places. It is simply information that voters can use however they want, one way or another, strong weight, little weight, no weight, negative weight. It's also something that, quite honestly, we put in there because we thought it was necessary because of a legal decision of the U.S. Supreme Court. And this is a very important point that gets to this. The U.S. Supreme Court threw out other systems in other states that weren't quite as open as this one for this reason. Well, political parties are private associations. They have control over who selects their official nominees. Now, of course, it begs the question about why, as taxpayers, are we paying for these party primaries of private organizations, including independents being forced to pay. But even more so, it suggested that that this provision was an important way to make sure we didn't run afoul of a successful court challenge. Quite honestly, if Governor Roberts, and I may well decide to join Governor Roberts to change this once we get the thing passed, but I don't think it would be anywhere near the problem that's noted before, because I say it's power that people have right now. They've just decided not to use it. And they don't have to use it under this plan.
Yeah, can you imagine the parties not using this when they've got 4 candidates running and they each want that endorsement from the party? They're going to use it. It doesn't make any sense to me if you keep saying the system doesn't belong to the parties because of private groups, and then tell me that in order to get past a legal question that you've manipulated the language in the measure that you might take away later in order to get past that question. So here we are, printing on these state-printed or county-printed ballots the endorsements of political parties, which we've never done before in state history. The closest we ever came was to give judges the right to use the word incumbent after their name on the ballot. And I got to tell you, I actively opposed that because I thought it gave incumbent judges the advantage. I don't think it's good to do this, and I would be happy to have this part go away.